One of the reasons why this is so important, and this is something which even the legal representatives may not be aware of, is that the right to equitable remuneration is a remuneration right. It is not an exclusive right. Now, because it is not an exclusive right, it cannot be transferred by contract. It can't be bought and sold in the way that other exclusive rights can be bought and sold. And this is very important because it means that if you have a performer that signs to a record label, the record company cannot touch the money they get from their neighbouring rights, even to recoup. Okay? They cannot transfer those rights across themselves and say, oh, well, you've got this neighbouring rights come in, give us that to recoup against money we've spent. No, this is an individual right to every individual performer. So it's a very important income stream now to performers. So how does this get collected and why does it get collected? Because obviously people don't want to pay money if they don't have to. Okay? It gets collected through what is known as collective management of rights. So what happens is artists give to their local collecting society the right to collect this money on their behalf. Okay? So artists say, okay, when you use our work, you have to pay us for it. The easiest way for us to get paid is to give our rights to one central society who will collect all the money and distribute it to us. And the reason that works is because the users of the music, the end users, otherwise, if you think about it legally, otherwise, when they wanted to broadcast a piece of music, they would need to go and get the permission of every individual performer, or at least even if they didn't have to get the permission, they would have to pay every individual performer on that sound recording, which is going to be a difficult process. So from a broadcaster's point of view, the collective management organisations are very useful because they then only have to go to one central place and say, okay, the artist has given you the rights, we automatically get the rights as long as we pay. So the broadcasters find it very useful to have an efficient collective management organisation in the middle of this process. So, in the case of PPL, what happens is this. The big broadcasters, like the BBC, who are PPL's biggest clients, they do a negotiation, and they do it on a 5-year basis. So every 5 years, PPL and the BBC sit down and say, okay, we want to be able to use any music that we want. PPL says, okay, well, we control, in other words, the artists have given us the right to over 92% of the recorded music output of the UK is in PPL as catalogue. So we control all that. So the BBC pay PPL several £million a year, for which they can then broadcast anything they want that's in the PPL catalogue. The other side of that is that in the contract with the BBC, the PPL insist that the BBC tell them all of the music that they use over the course of a year by the second of usage. So they tell you every single piece of music they have used and how many seconds of that music they used.
I don't know if I'm anticipating you, but if you could, in terms of the broadcasters and the rate that's licensed, clarify the difference between, say, if it was for sync purposes and in terms of explaining how it works with cable operation.
Okay, I'll come to that in a minute because synchronization is something separate and apart from this. This is just straight broadcast, okay? So the point about this is that in order to distribute the money accurately and fairly, PPL needs a certain amount of information. So by insisting as part of the deal that they are provided with the second of usage of the music, they are then able to allocate fairly to the performers the right amount of money they are due, because they know what's being used and where it's being used. And what they then do is they then give a certain weight to the different radio stations. So for instance, in the UK at the moment, Radio 2, BBC Radio 2, is the biggest broadcaster by demographic. It broadcasts to about 15.5 million people a week. Radio 1 is second, broadcasts to about 10 million people a week. And so a play on Radio 2 is worth more than a play anywhere else on UK radio, because they have the most listeners. Okay. So with the BBC providing PPL the accurate statistics of where the music is being played, it enables PPL to distribute more fairly to everybody whose music is being used, which is obviously an important component if you want to carry the whole music community with you. You know, if everybody feels that they are being fairly paid. So it's not just broadcast, though. In the UK, public performance anywhere is subject to being licensed. So actually, the biggest slice of the money that PPL collects is now from the public performance of work outside of broadcast. So it's public performance in pubs, clubs, hairdressers, shopping malls, fitness centres. All of these places have to be licensed. And they're often quite small licenses. The average pub in England, which is quite decent size, the average pub in England is paying something like £125 a year for the license to use music. And that's not a lot to them. But all those £125 build up, that total I talked about earlier. Now, where it is more difficult is that in those kind of public performance buildings, the distribution of the money is more difficult, because you cannot accurately get a figure for exactly what music is being used in all the pubs and clubs and shops and restaurants in the country. So you have to take a kind of a blueprint and extrapolate. So to give you an example, with the pubs, what PPL will do is they will go to the pubs and say, okay, you're playing music. What form does that play of music take? Are you playing CDs? Are you using a radio? How do you actually play the music? If they say they're using a radio, say, okay, which radio station do you play? If they tell them which radio station, then they know what the audience is hearing, because they know what the radio stations are playing. Okay. If they are playing CDs, they'll say, okay, the CDs that you play, would you say that it is more like the music of Radio 2, or the music of Radio 1, or the music of Smooth FM, or Classic FM? Again, you have a template on which you can decide how to distribute, because you can look at what those radio stations play, and it's a model. It's not going to be totally accurate. And sometimes people get very hung up on this. They say, well, that's all very well, but my auntie has a shop down in the West Country of England, and she plays only my music. So how am I going to get paid? And you have to then point out, okay, right, one play on Radio 2 is worth approximately 20 English pounds per minute. That's just from the recording side. Okay? Same for the songwriters. So if that one play on Radio 2 is worth £20 for a minute, which is obviously quite significant if you get a lot of play on Radio 2. Radio 2 has 15.5 million listeners. How much is one play in your auntie's shop going to be worth? If you divide that £20 by the two people who happen to be in the shop, basically it's not going to be very much. So although obviously I don't want to denigrate people who are earning small sums, it is not like people are missing out on serious amounts of money by using these kind of templates to distribute the money. Okay? And also PPL actually has a scheme that if for some reason your music is getting played to a lot of people, and there's one particular case where Newcastle United Football Club, at all their home games, they play a song called The Bladen Races, and they play a particular version of it to their stadium. And of course the stadium has 30,000 people in every week. So, you're talking about a significant number of people. So the person who's recording that can actually make a claim to PPL and say, this music is being used in our stadium every week to 30,000 people, and then PPL will make a payment based on that claim. But it needs to be something really significant for that to happen. Okay. Let's come to your question, Erica, which is to do with synchronization rights. Okay. One of the difficulties with the WPPT is that there are certain things which do not fall under its remit. Because what the WPPT relates to is audio recordings only. Audio-visual work does not qualify under that agreement for payment. With audio-visual work, it is incumbent on the copyright owner to make their own private deal with whoever is producing the audio-visual work. So again, to be clear, when you're making a sound recording only, the copyright owner is the person that actually owns the sound recording, is responsible for making it. As soon as you put a visual image with that sound recording, you have what is known as a synchronization right. You are putting the audio to the visual and actually effectively creating a new copyright in this new work. And the money that gets paid across for doing that is called a synchronization license. So the people actually have to pay to do that. Synchronization is not covered by the WPPT. So actually PPL does not license synchronization. Okay? And actually gets really quite complicated from here, which I will talk about in a minute, because I'm going to hand over to John to talk a little bit more about the treaties and so on. But when it comes to synchronization, and when it comes to interactivity, a whole different set of rules apply, which I will talk about after John. Thank you.